Hello, everybody. What's going on? I wanted to actually do a review of one of my videos, and then I want to kind of go over it, piece by piece. During this video, I did make a few mistakes, so I want to go over it and kind of clear it up. And I think sometimes it's the best way to do it. Instead of verification, I meant validation because there's a difference between verification and validation. So by the end of the video, I'll clear that up, but I'm going to go over this video with you and I'm going to prove everything in this video and kind of show you how, if you're ever dealing with a third party debt collector, you can knock them out like I did in a less than about, I think you could do it in probably 72 hours to probably 5 days. But once I go over this video, the knockout blow, in my opinion, this video has a lot. It's really what I'm trying to teach you is how to put a letter together to send to either a debt collector or a third party who you're going to use to act on your behalf to stop that third party debt collector for coming after you. And I got to talk about, the fragrance that I'm wearing today, which is Blessed Baraka from Initio. But in my opinion, I recommended this to somebody and they didn't get the full knowledge out of the video because sometimes people, I think what people want is they want somebody to just give them information instead of basically saying the information is here, research what I'm saying. Okay. In this video, I'm basically showing you how to get rid of third-party debt collectors and even original creditors in some instances, because some original creditors are not meeting these criteria. But I'm going to let it run, and yeah.
What's going on, people? I wanted to pop in here and kind of give you guys some game and some knowledge. And I did my video dealing with debt collectors while I was in Miami. Um, I pretty much told you what to do with debt collectors, but some people don't understand debt collection. And I'm telling y'all, none of these motherfuckers have the ability to make a claim. Like, none of them have an ability to put this shit on your credit. None of them. Well, unless it's a first-hand debt or a credit card debt. That's the only shit that they have the rights to collect on. Now, let me tell y'all one thing. When I watch all these so-called credit card gurus or these credit gurus, and they tell you all this bullshit. Remember, when I told you that credit was a tax issue, I told the credit card guru that credit was a tax issue, and now this credit card guru is using it. So now, they making money off of some advice I gave them for free.
Now that is funny because the so-called guru is now he's using this movement on against itself, which is funny to me. But like a lot of times when you see people, these so-called anti, so-called sovereignty movement, so-called whatever movement you want to call it, Moorish, whatever. A lot of times they don't have a high level of understanding of law, so they're really not going to be in your best interest. But you have to understand, and everybody, I want y'all to kind of follow along what a claim is. So a lot of times when I say stuff like they don't have the authority or the ability to make a claim, now you have to understand there's a difference between um, like dealing in the private, dealing in the public, and going into court. So sometimes people say, well, if these debt collectors are doing things they know is illegal, why would they do it if they know it's against the law? I mean, most of us break the law every day. Like sometimes the speed limit, well, not the law, but the so-called set of laws that are created by man, we break them all. It's impossible for you to operate a motor vehicle or, whatever semantical term you want to use at the time and move that motor vehicle down a street without some sort of violation, traveling violation. Okay, so you have to understand what a claim is. A claim is a set of operative facts creating a right. Creating a right enforceable in court. Okay, just because somebody has something that they can't bring in court, don't mean that they won't use deceptive tactics to get it in the court to place a levy or a lien against you. Okay, so keep that in mind. The court is separate than the private world. Okay. The term claim is generally synonymous with the phrase cause of action. So if you're sending a letter to somebody, you must know what a cause of action is. Let's go to what a cause of action is so you'll have that understanding. So when you're sending letters to these people, don't just send a letter with a bunch of statutes. It has to, you have to evoke some type of claim. Like you have a claim to the proceeds on the account. You have a claim to any interest in the account. You have a claim. You're challenging their claim to collect on the account due to some action it did. You see what I'm saying? So a cause of action. A cause of action is defined as a set of predefined factual elements that allow for a legal remedy. The factual elements needed for a specific cause of action can come from constitution, statute, judicial precedent, or administrative regulation. So now we know what a cause of action is. I don't have to read the rest of this, and we'll kind of get back to this. But you have to understand what a cause of action is. So when you're stating a letter or you're sending a validation letter, and I had a fire debt validation video, and it was like 20 something minutes, and the video didn't record. I was so pissed. Oh my God, that video was so good. And it didn't record. So now I had to figure out what I said and redo the video over. But I'll put it up and show you how to do a debt validation properly. A claim is a set of operative facts. Okay, so I said cause of action. Okay. Through some context, prefer to use one of the terms over the other. For example, in the field of insurance, you generally file a claim for coverage under a policy rather than file a cause of action for coverage under that policy. Attempting to file a lawsuit in which no claim is present will result in a dismissal of that lawsuit under Federal Rules of Civil Procedure 12b-6. Now, if you understand, this is where people talk about Trinsley versus Pagliaro. They try to say lawyers can't testify. Yes, lawyers can testify. Okay, but the lawyer cannot be the testifying party and both the party that's bringing the action, because that's a conflict of interest. And sometimes if you bring this up in court, then the court will still proceed on that case when they really don't have jurisdiction to do it. Be mindful of that too. So you got to hold all public officials accountable for failure to state a claim, as established in Ashcroft versus IQBAL and Bell Atlantic versus Twombly. Read these cases, okay? A claim must be plausible on its face and establish more than merely possibility that the defendant is liable to survive a 12b-6 motion to dismiss. All right, so I'm going to go back to this video, and hopefully it doesn't mess up, but I'm going to go back to this video and we'll get it.
I need to start charging people. But anyway, but the credit card guy, he's from my city, so he can, he can have that for free. He can get money off that. But let me tell y'all something, man. I really want to break down the credit hoax, or not the credit hoax, but the credit scam, because you're being scammed by all these third-party vendors who are making these claims off bogus accounts. They're committing fraud, but they're not using the FDCPA. What they're using is general contract law, or what they're using also is what's the law? It's not really a law, it's an unwritten law. So they're really not going by the FDCPA. That's why when some people send all these letters, they're like, why are these people not, acting? Why are they not responding? Why are they not? They don't have the original documents. Of course, they're supposed to have the original documents, because if you're going to make a claim that somebody owes a debt, they have a right to verify that claim. So with these...
That is correct. So if somebody is saying that you owe a debt, you should really ask them, is there a signed document that allows you to collect on this? And this is why in the videos I say that I always agree to pay. So when I'm sending a letter, I will always say that I agree to pay you. Even if I'm doing a debt validation, I'll agree to pay you. The reason why I say I agree to pay you is because I'm moving in honor. So if you understand how the UCC works, you will understand what a tender of payment is. And I'll bring that up for you, so you'll have a little knowledge of that. And it'll help you make it. So what a tender of payment is an offer to pay. Okay. So I have it set up to where I always have a contingency in things. So I'm never gonna just say, I'm not gonna pay you. I'm not doing that because that's dishonor. So they can go into court and say, hey, we tried to reach this guy. He wouldn't answer. He wouldn't do this. It's dishonor. Now, I do reject certain offers from people. And the reason why I do is because they don't have a claim, and I just don't have time to keep going back and forth with them for that little amount of money. If I'm going to deal with a debt collector, I'm going to send them my correspondence fee, and I'm going to try to make a lot of money off of it. Okay, so a tender of payment, you guys need to understand how to do conditional acceptances. A conditional acceptance is just as simple as offering to pay the person if they can provide all of the documents that you require. If they can't, they're in default and you don't have to pay them. You see what I'm saying? So that's how I'm able to get rid of third party debt collectors and get rid of debt immediately because I always agree to pay it. Okay. Tender of payment. If a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of the tender is governed by the principles of law applicable to tender of payment under a simple contract. If a tender of payment of an obligation to pay an instrument is made to the person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender, of the obligation of an endorser or an accommodation party, having the right of recourse with respect to obligation to which the tender relates. Okay? If a tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay the interest, see, listen what I'm saying, to pay the interest after the due date on the amount tendered is discharged. If a presentment is required with respect to an instrument and an obligor is able to and ready to pay on the due date at every place of payment stated in the instrument, the obligor is deemed to have made a tender of payment on the due date to the person entitled to enforce the instrument. Now, when you say this, when you understand what I stated, why people do not get remedy dealing with debt collectors, in most instances, people do not get remedy dealing with debt collectors because they do not know that they do not have they don't have a contract between the debt collector and them. So if you don't have a contract, it's okay for you to create a contract and create performance in terms that the other party has to abide by. Okay, so you're the one that's controlling the show, and if you don't control the show, they'll control you. All right, back to the future presentation.
People do is they'll keep coming after you, and then they won't respond to you with any type of like answer towards any of the answers that you're asking. So they'll put a vague letter, or they'll send you random documents to say that event happened that didn't happen. And a lot of times people just let them get away with that bullshit. First of all, let me tell y'all one thing. Do not dispute shit with somebody that does not have a right to make a claim. Okay? Don't dispute shit. All you need to do is verify. Once you verify, you ask for certain documents. Okay? And remember, do your own stuff. And because I'm going to keep this.
This is where I messed up and said verify. A debt verification is just verifying a debt that exists. Validation is completely different than a verification. Validation is almost you're requesting them to prove their claim and their ability to collect. If you do a verification in a debt collector's crafty, they're going to say, yeah, we verify the amount. But if you start asking for signed documents and things of that nature, most debts fall apart on that. Now, I know you've heard this from people to where they're saying that a contract has to be signed. And yeah, a contract has to be signed to be enforceable in court. It doesn't have to be signed outside of court because it constitutes as an implied contract. Okay. So some of these companies operate illegally and they'll force you into implied contracts. So you got to know, you have to know the difference between private and public when it comes to court. Okay.
This pretty vague high title stuff because some of these credit card companies are watching videos like this, and some of these
Correct.
people who are judges and all that stuff, it's the exact same thing. You could do a debt verification with a judgment. You could do a debt verification with a child support order. That's why I was telling y'all you got to attack the order. You always got to attack something at its beginning stages.
Now, if you've done consultations with me, I've told you about court orders and complaints and these things. These really are these are securities, okay? And the reason why they're securities is they're kind of what is called a deposit agreement. So if you understand what a deposit agreement or a pay order is, that's all a judge's order is. It's a pay order. You know what I'm saying? So like if somebody sends you a bill, it's a payment order. They're trying to order you to pay something. But the reality is they can't order you to pay anything if you haven't agreed to it. And really, when they send like that's why I did a video talking about when somebody sends you something in the mail, it's a withholding statement. So if a third party debt collector is receiving uh, a portfolio or a data tape full of information, what they're doing is they're creating a new contract with you. And that's what people don't get. They're trying to create a new contract with you. That's why they give you 30 days to respond. So they'll, and you read certain things and they'll say, well, they don't have to do anything if you don't respond after 30 days. No, you can do a debt validation at any time. And if they don't respond, then you can go into court and do your thing. But yeah, you know, you have to understand the difference between verification and validation. Anybody can sit there and say, yeah, the debt exists. That's a verification. But if you say, okay, I want to check out the validity of this debt, and as I said in the beginning, you don't have to say you agree to pay it. You can fight them till kicking and scratching. That's your philosophy. My philosophy is I always prepared 15 or 10 steps ahead of my enemy. And the reason why I do that is because I try to put it in a situation that I could defend it if anything pops off.
So, when it comes down to these fake creditors, they do not meet the terms of creditor under the Fair Debt Collection Practices Act. So how are they assuming the role of creditor? They don't. They legally do not have the right to place this information on your credit. So what they do is they send you notices, and when you don't answer these
Mm-hmm.
notices and you let them get away with this bullshit, what they'll do is they'll keep moving forward trying to collect the debt. But not me. The moment a debt collector, because I used to get tickets when I drove around in Florida, because sometimes I would have cases from like in Tampa into like Orlando. You know what I'm saying? So I would be driving from Orlando, Tampa, or certain places in Florida, and sometimes my cases would be 2 hours away. So I would get a lot of speeding tickets, because you try to make it there on time. And I used to use Hertz garbage GPS. Well, whenever somebody sends me a debt, like I already automatically accept and I agree to pay. So what you're doing is building your case up, not only building up your case to report to the credit bureau, you're building up your case just in case you need to go to court. Now, when a debt collector sends me something, I automatically ask them to send me the original contract. If you don't have the original contract, there ain't too much talking we need to do. So then when they send me that, I'll say, okay, I'll pay you in full if you can provide me the original contract. And then give me the authority that you have to collect on it. And if you have the authority to collect on it, then I'll pay you. If not, I'm not paying.
That is a big thing. You have to check out what authority that the debt collector is collecting on. Okay. A lot of times people don't know that because if somebody is acting as a third party, and when I was telling people I was dealing with I think it was an old like cable bill. And when I moved, I forgot to send my last payment. I just forgot because I had so much stuff going on. It didn't like, I didn't care. So they sent it to collections, and then the collections sent it to me, and that's the stuff that I'm putting on YouTube, where you can see me get rid of that in less than 5 days. The reason why is I struck quick. As soon as I received it, I acted, and as soon as they got a notice from me, they backed up. They were like, "Yeah, we're not messing with this," because what I brought up would have brought them in court, and I would have got them caught up for a felony if they would have proceeded on it. I wouldn't have got them under the FDCPA. I would have got them for a felony. So a lot of times when you know your state law, you can kind of invoke a little bit more. But I want to go into certain things on this video that I couldn't flesh out because it's only, back in the days I used to only do 10-minute videos. Um, but I'm gonna go over some things that I didn't flesh out on this video.
And you nothing. 99.9% of chance they don't got none of that shit. They can send you a copy, but a copy is not an original. And if it's a loan, you have a right to call a loan due at any time. That's why you know it's not a loan.
That is correct. So you have the authority, a loan can be called due at any time. The number one thing that people have to understand is you have what is called claims to an instrument. Okay. You have to, like, some of the stuff that people ask, like a lot of times I get a lot of questions, right? And I don't use the UCC so tough, even though I've already read the UCC in its entirety. But you have to understand there's elements of the UCC because this is really what these people are using. And I've seen attorneys say, oh, they're not using the UCC. Yes, they are. They're using it. So a person taking an instrument, other than a person having the rights as a holder in due course, is subject to a claim of property or possessory right in the instrument or its proceeds, including a claim to rescind a negotiation. So if you remember, I did a video talking about rescission. So some people who are going through foreclosure, you guys really need to watch that video because in that video, I'm showing you how to do a rescission and I'm putting it on the internet for free. So if you're going through foreclosure, you need to either recommend that video to somebody or show them that video so they can actually see what I'm talking about. See, you have a right to rescind negotiation, okay, and recover the instrument or its proceeds. A person having the rights of a holder in due course takes free of the claim to the instrument. So if you notice this, whenever you're dealing with a debt collector, you could do a debt validation on them. So that means that they're not the holder in due course. So they do not have the authority to collect technically. So you have to understand who the holder in due course is. So if you don't understand what and who a holder in due course is, it's going to be very hard for you to understand this and what a holder in due course is. A holder is a person that takes, the instrument free of all claims and defenses. If they take it subject to your defenses and claims, then they're not a holder in due course and they really don't have the authority to collect. Okay, so this is subsection 3-302 of the Uniform Commercial Code, all right? Holder in due course, subject to subsection C and section 3-106D. Holder in due course means the holder of an instrument if the instrument, when issued is or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. So I know somebody who did a consultation to understand why I told you you have to authenticate the record. Okay. Only you can authenticate the record because you're technically the holder in due course, but you don't know it and you haven't asserted it yet. Okay. The holder took the instrument for value in good faith without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to the payment of another instrument issued as part of the same series, without notice that the instrument contains an unauthorized signature or has been altered, without notice of any claim to the instrument described in section 3-306, and without notice that any party has a defense or claim in recoupment described in section 3-305. Okay, so now, to me, this is a little bit more archaic, but I'm going over this video to bring it back up to date because I don't teach this anymore. You know what I'm saying? But I'm basically showing you how, to deal with these elements. And you have to know what a holder in due course is. If the person is not holder in due course, they don't have the right to make you pay an instrument. Okay. So notice of discharge of a party or other than the discharge in an insolvency proceeding is not of a defense under the subsection A but a discharge is effective against a person who became the holder in due course with notice of the discharge. So, like, in if you're dealing with these instruments, you can become the holder in due course. Okay, if you're dealing with something that only you can verify your signature on, and no one else can verify your signature, then you're pretty much the holder in due course. So what happens is when you get into a so-called debt, you both become the holder. Okay, but you never assert your interest. So then they become the interest holder, and they do what is called withholding statements to you that you think is bills. Okay. So, public filing or recording of the document does not itself constitute a notice of a defense, claim and recoupment, or claim to an instrument. Okay, so you can go through this subsection, and because I'm not going to go over this all day because I got stuff to do. But you can go over this, subsection and read it read it on your own. So I'm going to go back to the feature presentation, and then I'll chime in, and I'm going to show you some stuff that'll help you guys put your debt validation letters together if you need it. Correct. 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 Now, you hear this from a lot of people. They tell you that you must send stuff certified mail. Now, I used to be a trial witness in foreclosure trials, and I'm going to tell you this firsthand: you do not have to send stuff certified mail. Um, you can have somebody else send it for you. Okay. You can have a cousin, you can have a relative, you can have somebody else send it for you. As long as they have like an affidavit or something proving they put it in a box, you can use that at court. But all you have to prove is that you sent it. You don't have to prove that they received it. And you see a lot of people tell you to send something and have that return green receipt. You don't need that. All you have to do is prove you sent something. That's why people will sit there and they'll accelerate stuff and they'll send stuff. Some people will actually send stuff to the wrong address. They will purposely send stuff to the wrong address. And I had this happen to me one time. Somebody purposely sent it to an old address that I didn't live at and then tried to accelerate something. So you have to be very careful. And that's why they kind of have, the credit bureau has your address on there so people can get in touch with you. And then that's the last address you have on public records or files. So if you don't have any traffic tickets, you don't have nothing else, if somebody skip traces you, then pretty much all they have is your credit report. Correct. Credit applications is the initial security. So when you see me read that about the holder in due course, or you see me what I just read talking about a series of securities, an application uh, is it's basically how they get the security interest in the account. Because your information is considered a credit profile, and I've told this to people multiple times. If you need more reference, you can look at my video where I'm talking about how CPNs are not illegal. Okay, if you need more reference, you can also look in the upper right hand corner, and I'll flash videos for reference too, so you can click on those videos and follow along, so you can get this stuff quicker. Because sometimes people ask me, they say, "You talk about all this stuff, you do it in fragments." It's because I don't want to bombard people with information to a point where they start forgetting what I'm talking about. So the key is for me to put this in a chunk or in a good enough sense to where you can go on and doing your own research. A lot of the stuff that y'all be afraid of, a lot of the stuff that keeps y'all up at night, like foreclosures, child support, that shit is not as scary as you think it is. You think it's scary because you're going through it. Everybody thinks what they're going through is the worst shit on the planet because you're going through it. But really, you got to go through it to understand it. Child support is easy as hell when you understand. You can do this stuff, this video for child support. You could challenge the balance of child support. You could do a debt validation on child support. Um, you could do it on mortgages. You could do this on everything. But once you start, I'm gonna start going over some things in this call on this. But yeah, people, this is gonna be a video that you should definitely see. Correct. Yes. This could be written off as a bad debt. Um, and you can look under this section of the. I'll show you under the IRS code. So under section 434, 435, right? This is what I'm talking about. So, like, if somebody, if a third party debt collector can't collect, they can they can step in the shoes. If they have an assignment, they can step in the shoes as the original creditor and write this off. So, like, sometimes when people ask me for stuff like Form 56s and all that other stuff, like, people don't understand there's a difference between dealing with contracts and dealing with the IRS and dealing with taxes. Okay, I don't bring up Form 56 because Form 56s aren't really needed. You know what I'm saying? There's other ways to do that. So um, when you understand that, like, sometimes people comment in my comment section about Form 56s, I don't need them. So a lot of the stuff that people are telling you, I don't need them because I know you don't need them. That doesn't mean that what somebody is saying is wrong. It's just that's not a philosophy that I need. But you guys, feel free to use whatever philosophy works for you. I don't need people in my comment section telling me I'm getting remedy doing this. Go ahead, do it. If you get remedy, that's the point. But yeah, so we'll get back to that. That is a fact. That is a fact. Debt collectors are afraid of the FDCPA because they don't want to be sued. Now, if a debt is for 40, 50,000, right? The debt collector doesn't is not going to be as afraid of pushing the boundaries of the FDCPA. But if the debt is like $1,000, $2,000, they ain't coming after that because if they make one violation and you bring it up, then you can bring it into court, and that's $1,000 per violation. So it's not worth it. But if it's something like 40, 50,000, they'll just take the gamble because if you don't know your rights, they can still collect on that. So I hope people understand there's some strategy to it because they have to weigh what is they have to weigh what's profitable. Boom. Now we're getting to the big dog. We're getting to the big dog. This is the big dog. So when I state this, when I did the video at the time, I didn't know how to do, I wasn't a big technological person. I didn't know how to do this. I still ain't, I'm not very technologically advanced. Well, most states, so this we'll go over this, right? So many states have laws regulating debt collection to which agencies must adhere. Now, you want to understand why states have this because debt collectors will try to collect debt and not pay taxes on it. So the state has to regulate debt collection. Just like I'm saying when I said about consumer law has little to nothing to do about you, that's the same thing about these debt collection preventative laws. It's to stop debt collectors from being able to collect money and not pay tax to the state and the federal government because most of them will. You know what I'm saying? They'll collect the debt and not pay taxes to them. I'm not saying all, but some won't. Okay. In addition, many states and a few cities require collection agencies to be licensed. It is important for a debt collection agencies to understand this practice because it is a sign of professionalism and commitment to the industry. If you intend to conduct consumer debt collection services in the United States, you may require a license. The following states that require consumer debt collectors be licensed. Okay, Alabama, Alaska, Arizona, Arkansas, or like that girl said, Arkansas, Colorado, Connecticut, Delaware, City of Wilmington, District of Columbia, Florida, Hawaii, Idaho, Illinois, etc. I'm just gonna let y'all go ahead and look at the videos. So in the state of Wisconsin, we have a website that I already go to. Like if a so-called debt collector send me a letter, I go look and see if they're registered in our state because me being from Wisconsin, I want to make sure that that's my first way to knock them out. So if they're not registered in our state or they let their registration lapse, if they come after me, I'm gonna send them a notice, basically telling them that I'm gonna charge them $5,000-$10,000, and then I can go in small claims and collect on it. But or I could go in any court and collect on it. But yeah, so these states, make sure if you need to pause it, you need to look it up, look these states up, and make sure if they're your state, and if it's not your state, uh, you still have defenses, but you wouldn't use that as a defense, like California, Georgia, Kentucky, Mississippi, Missouri, Montana, New York, Oklahoma, South Carolina, Vermont, and Virginia. There's no license requirements. But debt collectors still have to be they still have to be protected because if they injure you, you can file a claim against them. But I'm gonna show you that later. Yes, debt collectors do have to be bonded. So, what is a collection agency? Collection agencies collect debt in a regularly managed sensitive data, such as a consumer's personal information and financial details. This is why I did the silver bullet video to tell you that these people are engaged in what? Identity theft. Since the collection agency is regarded as a high risk company, surety bonds for collection agencies are necessity. See, they must be bonded because if they're not bonded, I mean, if you know how to put it together, you can request their bond and file a claim on their bond if they do any injury to you or they damage any property or, you know what I'm saying, ruin your credit. So there's other ways besides the FDCPA. That's why I don't really bring up the FDCPA, in my opinion, because I have better ways. You see what I'm saying? So the collection agency bond ensures the credibility, dependability of the agencies being bonded. So so we know now that they must be bonded and they must be insured. Now they don't always have to be licensed, but they have to be insured. They have to be insured. So insurance is critical for protecting an investment you made in your business. This is especially true when starting a collection agency or a debt buying firm. See what I'm saying? So this is when I was talking about the video. Consumer law is not just for the consumer; it's to protect these companies too, or people who buy debts, who buy notes, who buy securities, who trade securities in the secondary market, who pool mortgage-backed securities, because they have to protect them because there has to be disclosure. Because if there's no disclosure, you have to keep in mind that the government is invested in these companies too. So they have to have disclosure. So that's why they have these provisions so debt buyers don't inherit a problem that they didn't know about, because then that would basically turn over the secondary market or the stock market overnight. It would just collapse damn near everything. Okay. While there is not a single specific product for debt collection insurance, there are several important types of insurance policies that you will need to guard against possible claim scenarios. So once you find out who they're insured by, you can file a claim against them. Okay, so I'm not gonna get into that because then keep me going on forever. Um, so I'm gonna get back to the video so I can kind of wrap this up. It's triggering me that I'm saying verified, but they failed to validate the debt because now they don't have to have a bond or insurance to collect on the debt. But if you're a state, they have to be licensed, and they're not licensed, they have to stop instantly. So pretty much almost everything in this video, and if you add that with some of the things that I brought up in the silver bullet video, it should pretty much, I mean, you should be able to knock out that. And like anybody that sends you a letter saying you owe them money, you should be able to knock it out very easily. Correct. That is correct because a tax is a charge. So if somebody's sending you a so-called bill, it's a withholding fee. Now, when you understand these things, it would take me a longer video, and I'm already just ready. I'm already done with this video mentally. But yeah, when you understand the things in this video that I initially did, I'm just fleshing it over so you guys have a greater level of understanding that if you're dealing with debt collectors, you want to ask for these things. And if not, you want to go on a search or a diatribe on your own, not a diatribe, but a search on your own to find these elements. And you can request them in the letter. Like my letters don't have to reference ton of law. I don't have to reference Title 15 statutes. I don't have to do none of that. But sometimes I do put them in there just as kind of a little bit of a little sauce on the deal. But yeah, you don't really have to write. No, there's no magical letter. Like with a lot of stuff that people ask me, it's really no magic. It's just knowledge. Because the key is once you have enough knowledge, you don't have to write 10-page letters. You only write like 1 or 2 pages because that's all you need. But yeah, I think I'm gonna conclude it after this little bit. That is correct. You can, if somebody cannot prove a claim, you can send them a bill for your time. So, like, if you're dealing with a debt collector and say you have a bill and you said, you guys wasted an hour of my life, you wasted 2 hours of my life, you can send them a bill. You can send them a bill for whatever you want to. You can start going after them like they went after you. So, it's not any fun when you in control. It's funny when somebody steals your car or steals your house, they think that's funny. But when you start going after them and putting liens on them and being in the position of where you can put a lien on their whole company, you know, that's not fun for them. They don't like that. Well, I hope y'all learned something. I'm out.